All right, good morning. It looks like everyone is here, so I think we're good to get started. Good morning, everyone. Today is March 31st, 2025, and the time is 9:30 a.m. This is a final pre-hearing conference matter of James McCall before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We are convening remotely over Zoom, and this pre-hearing conference is being recorded. The Honorable Judith A. Cowin will be the presiding officer over today's pre-hearing conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission. And this matter is now before Judge Cowin.
Good morning.
Morning, Judge.
Good morning, Your Honor. How are you?
I'm well, thank you. How are you?
I'm good.
Good. Today, the purpose of the hearing today is to review the joint pre-hearing memorandum and be certain that there are no outstanding matters before we have the hearing. I have received and reviewed the joint pre-hearing memorandum, and I have a few questions. First of all, are there any disputes about any of the exhibits? Mr. McCall, do you have any dispute about the admissibility of any of the division's exhibits?
No, Your Honor.
Okay, Ms. Chisholm, same question for you. Do you have any problems with any of the exhibits that the respondent intends to offer?
Yes, as I mentioned in the last pre-hearing conference, the division would object to the admissibility of what I believe has been marked as Exhibit B for the respondent. It's a Facebook friend request notification screenshot. I believe Mr. McCall will testify that he received this roughly a year after the case that we're talking about was closed and he was no longer employed by Fitchburg Police. I would just argue it's not relevant to the case at hand.
Well, but as I understand it, the friend's request is from one of the alleged victims. Is that correct? Am I correct?
I believe
Mr.
that's
McCall?
what Mr. McCall will
Yes,
testify to.
That is
Okay.
correct, Your Honor.
Okay, so I assume that Mr. McCall's reasoning is that if this alleged victim is making a friend's request, if she were a victim, why would she make a friend's request? That wouldn't make sense. So because she's made a friend's request, it's relevant to whether the allegation against her actually occurred. Is that what you would say, Mr. McCall?
I would say that I'm not disputing that the conversation happened, Your Honor. What I'm disputing is how the police department and the commission is making it out that she is the actual alleged victim. Like I said, during when initially she sent the photo to the Stop It app, like there was parts of the conversation that was deleted out. There was parts of the conversation that was whited out, which because she told the department that she did not conversate back with me to make herself seem like it was more of a me and not a conversation that we were having. So what I'm saying is the friend request after a year of not even having any conversation with this young female, that it would be relevant for the simple fact is it shows that she was not as distraught as the department had made her out to be. That's what I'm saying, Your Honor.
Okay, you used one word when she sent you something that had parts. What did she send you? You said
The friend request, Your Honor.
The friend's request. Okay.
Yes.
That was when parts of the conversation were supposedly whited out?
No, Your Honor. That was the initial Snapchat conversation that.
Oh, that's the word I missed. So when she sent the Snapchat, that's where the words were whited out. Is that right?
That's correct. When it was sent to the Stop It app.
Right.
Your Honor, there were no words whited out. Well, I think this should all come out at the hearing. I don't think that Mr. McCall should testify to what he thinks the evidence will be. a full copy of that Snapchat will be admitted into evidence. And I think going over it line by line right now, I could read it line by line if you'd like, but I think talking about certain lines is just going to muddy the waters.
Well, we don't have a jury, so if you're saying a full copy of the Snapchat will come into evidence. And now,
And so the document that I object to is Exhibit B for the respondent, which is about
okay,
a year
I
later,
understand.
according to Mr. McCall. So I would argue that just the mere passage of time has no relevance to what happened on February 14th, 2023.
Okay, I think that will go to the weight of the evidence, and I think that I will allow the admission of that evidence. So that's B. That's B for Mr. McCall. Okay. And if it's too late, then that would go to the relevance, or if it's very late. All right. No other disputes about any exhibits, Ms. Chisholm?
No.
Okay. Now, Ms. Chisholm, how do you? I don't quite understand. You have none of the alleged victims testifying. How am I going to make credibility determinations without the percipient witnesses, the people to whom this happened, to whom these things allegedly happened?
Right. Well, that herein lies the problem with sexual harassment, sexual misconduct in the workplace. These women work at the Fitchburg Police Department, or they did. They live in the community. Mr. McCall, I believe, will testify to his close ties with the community. He's well known. We have one witness who is willing to testify. The other women are not willing to testify. I believe they've weighed the pros and cons of their testimony, and they've decided not to testify. We do have the internal affairs captain who did the investigation, who is now the chief of police. He will testify to his investigation. It was very thorough. He took down detailed notes of their testimony. I would suggest that their testimony is going to, or his testimony about what they said, it is hearsay, but it is admissible in this hearing. It's reliable hearsay. There's repetitive statements. There's the same MO with many of these women. There's pictures sent. There's the same comments about certain body parts. There's the same turn of phrases that Mr. McCall uses with these women. So I believe it's reliable hearsay, and it's this now chief worked with Mr. McCall. I believe he is a witness himself to the atmosphere in the department. So I would suggest that once you hear the testimony and the testimony of one of the witnesses who will testify, given the repetitive nature of what was told to this chief, I believe you will be able to rely on some of this hearsay.
Who is the witness who will testify?
Her initials are, I can go into what she's.
No, but is she listed?
Yes. She is listed as the under section 5, the names of the witnesses for the division. She's at letter C.
Okay. 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 Okay, well, I'm sure you understand the risks of not having witnesses actually testify who were or are the complaining witnesses.
Yes, we're aware of that. It's a balancing act to not re-victimize people, but to also hold people accountable.
Okay. You
Your
use the
Honor,
word, yes,
sorry.
yes, Mr.
I
McCall,
I
yes,
apologize.
no,
What I'm going to say, I'm going to object to allowing Mr. Giannini to speak on behalf of anyone. For first of all, even though this is not a criminal case, I believe it violates my constitutional right to be able to face my accusers and to ask my accusers questions and to question them and cross-examine them. So to allow Mr. Giannini to speak on behalf of alleged victims, because that's exactly what it is, on alleged misconduct that Ms. Chisholm says that happened, even though that there's no evidence that I did anything. There's no pictures, there are no videos, there are no text message of any sort that Mr. Giannini has, nor does the commission have, other than the ones that I've admit that I have done. So therefore, like I said, it violates my rights, my Sixth Amendment right to face my accusers, and to allow Mr. Giannini to speak on behalf of a investigation that he did that did not have any audio of any interview, and I have not seen any notes from Mr. Giannini to say exactly what these alleged victims said.
okay. Ms. Chisholm, have you shared the notes or the report of Mr. Giannini, of Chief Giannini, with the respondent?
Yes, he has all of that. I would say under 38, there is, the division is allowed, just as Mr. McCall is allowed, to bring in hearsay evidence as long as it's reliable. There's no right to confrontation in a civil proceeding. This is the report has been provided. It was provided prior to Mr. McCall's termination and subsequent resignation from that department. He's had all of this evidence. I provided it myself as well. It's a very thorough report, and I'm sure he can cross-examine the chief on his report.
Okay, Mr. McCall, Ms. Chisholm states that you have the reports, you have Mr. Giannini's report of his interviews.
Your Honor, I don't have the report of his interviews. I have the report, his final report of the investigation. There are no, like, his notes that he made during the the alleged interviews. I don't have those because I don't think the commission has those, because I don't think he issued those, and there are no audio recordings of said interviews. So therefore, Mr. Giannini could have written anything in those reports. They could have said anything, and he could have, to me, he made the report out to benefit the department. That's how I feel. And there's no evidence to say that he didn't do it.
Your Honor, I would just note that this is a report. It's lengthy. He spoke to, I believe, 21 people. Of those, roughly 9 or 10 had complaints about Mr. McCall, but there's plenty of them who said nothing ever happened. He was totally fine with me. So the chief, I would argue, has written down what these people said, good or bad, about Mr. McCall.
Well, the report is admissible in a proceeding of this type, Mr. McCall. This is a hearing under Chapter 30A, and reliable hearsay is admissible. And you can cross-examine the chief, of course, about anything, about whether he has notes, whether he made notes. And if he didn't make any notes, then that, of course, goes to the reliability of the hearsay. It becomes less reliable, perhaps, if he didn't make any notes.
Right.
And you can question him about anything related in the reports or in his notes. And There are no notes why he didn't take notes and why he can't, how he can remember without any notes, etc. As I've indicated before, it's preferable to have live witness testimony, but as Ms. Chisholm has indicated, there are problems in a matter of this nature, not problems, but difficulties in having witnesses testify. And of course, I can consider, when I consider the hearsay, it could be that the fact that there are no actual witnesses testifying, that could affect my decision. However, the hearsay is admissible. So the witness, Chief Giannini, can testify to the contents of his reports and what these people said to him.
And there is a female
allegedly.
witness.
Wait, one person at a time.
Sorry. Go ahead,
Yeah.
Ms. Chisholm.
Ms. Chisholm, you were started speaking first. What were you saying?
Yes, I just want to make it clear, there is an alleged victim that will be.
Yes, I
testifying.
understand. You told me that. Mr. McCall, what did you want to say?
I was just saying that you said that he can testify to what they said, but I said allegedly what they said because we don't know exactly what they said because we don't have the notes. We don't, this is police 101. And police 101, when you're investigating, when you start an investigation, especially an investigation of this magnitude, you want to at least, at the minimum, audio record your interviews. And the fact that he did not do that, it's he's been a police officer for 20 plus years. He's now the chief of police. How can you not, at the basic, especially on this magnitude, state that you did not interview, audio record? It makes no sense. We do that when I was a police officer in my 18 plus years. The first thing we do is we ask alleged witnesses, whether they're a victim or a suspect, can we audio or video record this recording, this interview? It's basic police 101. And the fact that he did not do that, it should show. Also, the fact that, and I know Ms. Chisholm says that because I'm very connected to the community and that people don't want to come forward. If someone did something to me, and I'm making an allegation that someone did something to me, I am going to stand on my allegation and I'm going to testify against that individual that allegedly perpetrated a crime against me. And the fact that the commission only has one witness out of 9 also goes to show the validity of this and I'll call it how I've called it. I wouldn't even call it an investigation. It was a witch hunt.
Well, all of what you said to me, Mr. McCall, is fodder for your cross-examination of Chief Giannini. And
Okay.
you'll have an opportunity to cross-examine him on the entire subject of the lack of audio recordings and the lack of notes, if there is a lack of notes
Sure.
behind his report. No, let me see. I wonder, what does the word tag mean in 7L of the joint pre-hearing memorandum?
Your Honor, in social media, when someone has an account and they see a meme or a picture or some funny saying or an obnoxious saying or a obscene saying, they can take their account, post the picture, and they can put, it's called tagging. It's when you put someone else's account is linked to that picture or saying or meme. So it publicly associates someone else's account with what is written or shown on a picture as part of a social media post.
So is this, so you mean if I have an account and then I see a picture of a dog that I want to send to someone who I know likes dogs, if that person is somehow that person's account is linked with mine, I can take a picture and it automatically sends the picture to that person, or I can click something and it will go to that person?
You can, it's hard to describe it. You're not sending a picture, you're just putting their account, linking it to the picture so that everyone can see that you like the picture and that you're associating another account with the picture or saying.
When you say everyone can see it, who else can see it? Who's
Yeah,
everyone?
everyone can see it. Everyone on that app.
Everyone
that
on that
website.
app. So it's not everyone, it's everyone on that app.
Right, which there's millions of people on the app.
Excuse me?
There could be up to millions of people on the app.
So when you tag the picture, it goes to anybody else's account who's linked with that account?
You tag another account, so you associate another person with an account. So if you like dogs and you tag a friend with the dog picture, you're essentially saying you'd like this picture, or you're now associated with this picture. You can untag yourself from a picture or a saying, and you might not want to be associated with it, but it's out there. Anybody that is on your web page or your app page can see everything you've done with that picture, including all the people you've tagged in that picture or post.
These are dangerous things.
And Your Honor, may I? And
Yes.
that's why I'm going to object to that being utilized as an evidence for the commission for during Mr. Giannini's report. The individual that I did tag in that, which I don't deny that we tagged because I tagged because her and I had a relationship, a friendship relationship, another relationship. She did not have an issue with me tagging her. And like Attorney Chisholm said, she could have very well untagged herself, which she did not. That's because she wasn't upset. It was Mr. Giannini during his investigation who felt that it was wrong. But the alleged witness that was tagged didn't care because her and I tagged each other in things all the time. So I would object to the commission being able to use that.
Didn't you just tell me you didn't have any objection to any of the division's exhibits?
Yes, Your Honor. It just came out. I apologize.
Your Honor, Mr. McCall admits to.
Just a minute, Ms. Chisholm. So, Mr. McCall, you're telling me you have an objection to one of the exhibits now?
That is correct.
Which one is this? What letter?
That I don't have that up right now, Your Honor.
I
It's
guess that,
it was the one where the tagging occurred, Your Honor.
okay, well, I know which one that is. That's 7L. 7L, the respondent tagged a female coworker in an Instagram post that stated, tag someone who deserves a glass of wine and unproblematic dick. The respondent has tagged the same female coworker in the past on posts that people may deem inappropriate. So you object to that Instagram post coming in?
That is correct, Your Honor, because like I said, the alleged witness did not have an issue with it. It says it in Mr. Giannini's report that she did not have an issue with it. It was another coworker who saw it and said, "Oh, she had an issue with it." But if the alleged victim didn't have an issue with it, then why should it be submitted
Okay,
or be
so
allowed to
you're
be?
telling, excuse me, you're telling me that that in Chief Giannini's report, it states that the alleged victim didn't have an issue with your tagging her with that remark. Is that right?
That is correct, Your
And
Honor.
it says that in his report.
Yes, it does, Your Honor.
All right, well, there's no problem with it coming in. It's relevant. In his report, in your behalf, Mr. McCall, it says, according to what you tell me, it says that the alleged victim says she didn't have an issue with it. So I don't see any problem with the admissibility of that exhibit. But I do ask you now, Mr. Chisholm, Mr. McCall, have you gone over all the exhibits? Because I want to know beforehand any objections that you have to the exhibit so that we don't have to go through this. I mean, I'm happy to hear whatever objections you have, but it's better to hear them now so that I can make decisions and you know in advance of the hearing what's going to happen rather than on the
Yes,
day
Your
of the hearing, things being up in the air. So have you gone through the exhibits and you are content with the others coming in?
Yes, Your Honor. I have
Okay.
gone through it, and I am content with every other
Okay.
exhibit.
Okay. Now, Ms. Chisholm, why can't you testify in person?
Your Honor, we, as part of our conversation in the last pre-hearing conference, there was, the division believed that it was given the opportunity to have certain witnesses, if they were able to testify over Zoom, if that would be more comfortable. Mr. McCall represents himself. There's the obvious fact of him cross-examining people that he's allegedly victimized. I believe having her testify over Zoom is an accommodation that is not unrealistic, and I think it would be helpful in this case. Like I said, these people work together. They live in the same town. Mr. McCall is a postman in the town. It would be beneficial to have this victim testify over Zoom rather than in Boston. She lives in Fitchburg. And I would just ask that she be allowed to testify over Zoom.
Well, I must say that when I indicated at the last hearing that witnesses could testify by Zoom, perhaps my thinking was in error, but my thinking was that if people had difficulty coming in because of the distance from Fitchburg to Boston or because of child care or elder care matters that they had at home or anything of that nature, I didn't have a problem with them testifying. But you are telling me that this is simply that she doesn't want to face her accuser.
No, that's an assumption on my part. Given the option to testify in person or over Zoom, I believe she would rather testify over Zoom. But if she's not allowed to testify over Zoom, then, she's going to testify however Your Honor makes her, asks her to testify.
This is posing a difficult problem because she's the only live witness that you have. And it seems to me that she should testify in person. Zoom is an accommodation for people with a hardship. I don't think it should be just because somebody doesn't want to testify in person. So I'm going to rule that she is an exception to what I said before when I was thinking somebody could testify in person, but there's a difference between 1 of 9 people or 2 or 3 of 9 people testifying by Zoom. But it becomes a different matter when the only alleged victim testifying is testifying by Zoom. And I think she should come in and testify in person. If there's any reason that it's a particular hardship, you can present it to me. You can present something in writing. What is the date of the actual hearing? What date do we have?
It's April
Lizzie?
8th. Judge
April
Cowin.
8th?
Yep.
Okay, so you have time between now and then, Ms. Chisholm, if this presents an extreme hardship, you can present something in writing, and I will, if necessary, have another hearing on the matter. But it
Okay.
seems to me that, well, I know that wasn't my intent in making my ruling, that witnesses could testify by Zoom if necessary.
Okay.
Okay.
And Judge Cowin, just for the record, the
Yes.
exhibit that was referenced earlier about the Instagram post, was that the division's exhibit M as in Mike? I just want to make sure
Wait a minute,
we're clear about
just 1
that.
minute.
Yep.
What was your question again, please, Ms. Smith?
I was just asking if the exhibit that Mr. McCall objected to was the division's exhibit M as in Mike, the Instagram post.
What number M?
On
9M? 9M?
So I am looking at the division's exhibit list.
Yeah. Yes, I can see my pre-hearing conference report. It is 9M.
Great, thank you.
Now, what is the difference between Exhibit 9M, the Instagram screenshot, and Exhibit 10A, the unredacted Snapchat screenshot? Okay, Ms. Chisholm, is there a difference? And if there is, what is the difference?
Yes, so Instagram is an app, and so Snapchat is a totally separate app. These are completely separate exhibits because they're one of them. 9M is an Instagram screenshot that we just discussed with a coworker, and exhibit 10A is Mr. McCall's exhibit, and it's a Snapchat screenshot with a completely different person. It's a Snapchat, it's a different app, and it's a screenshot of what was said on that app with a juvenile female. And then the Instagram screenshot is of a post that Mr. McCall tagged a coworker in on a different date, completely different people that he's dealing with each of these screenshots.
Okay. So 9M is a post that the respondent tagged a coworker with. That was the juvenile.
Yes.
Was going from school to the place to eat. Is that right?
No, 9M is Instagram, and that was what you read. Tag someone who deserves a glass of wine and an unproblematic dick. That is something he tagged a coworker in. And then
Okay, all right.
the juvenile is when he speaks to her in a suggestive manner. That is on Snapchat on February 14th, 2023. And that is also part of the
Is that
division
10, is that Snapchat 10A?
That's 10A, that's the respondents. I also have it as the division's exhibit, and that's on 9H.
So, okay, I think I follow you. So are 9H and 10A the same?
Yes.
Okay, Mr. McCall, why do we need two exhibits that are the same? If 9H is the Valentine's Day Snapchat screenshot between James McCall and Juvenile, February 14th, 2023. and 10A is the unredacted Snapchat screenshot. Is there any difference between the two, Mr. McCall?
So unfortunately, Your Honor, I don't have those documents in front of me, so I'm not sure if 9H and 10A, if one is the initial one that she sent through, or the department got through the Stop It app, and then the other one is the actual full conversation that happened. Like I said, I don't have that in front of me. My computer, I'm actually using my cell phone as my internet because my internet just went down prior to us getting on, so I can't get to the exhibitions right now.
Okay, well, all right, it won't be a problem if it is a duplicate. It won't matter all that much, but on the day of the hearing, Mr. McCall, you will need a list. You'll need a list of the exhibits, and it would be good if you also have the joint pre-hearing memorandum in front of you, which
I will have
contains
that.
a list of the exhibits. Okay. Okay. As you can see from our discussion this morning, I am not familiar with any of these words or apps or anything, Snapchat and whatever the others. I do know what a screenshot is, so at the hearing, it will be very helpful if any time you use any of the words, at least the first time, explain exactly what it is, although I now have an explanation of what tagging is. But anytime these words are used, it's very helpful, or I'll just have to stop you anyway to get an explanation of what you're talking about. And bear in mind when you're questioning witnesses that I am not familiar with what each of these things is or means. Now let's see. You mentioned in this pretrial memorandum that we need a closed session for the testimony of the complaining witnesses. So that would be only for, is that right, Ms. Chisholm?
Yes, I would just ask that her testimony be closed and that we use her initials at any other point in the hearing. And the initials of any other alleged victim, most especially the juvenile alleged victim.
Okay. All right. Mr. McCall, you have no problem with that?
I don't have any problem with using initials, Your Honor.
Okay, and we will close the session for the testimony of now. So, and we will be careful as we can to use only initials for the testimony of all the alleged victims. And if we have to stop and think about it, we'll have to do that, but we will call each alleged victim by his or her initials only. Those are the only matters I wish to address as a result of the joint pre-hearing memorandum. Is there anything else that you wish to address, Ms. Chisholm?
No, Your Honor.
Okay, Mr. McCall, is there anything else you wish to address?
No, Your Honor.
Okay, then I believe we are all set. The hearing in this matter will occur on April 8th. And what is the time, Ms. Smith? Is that 9:30 or 10, did we say?
I have it listed as 9:30 a.m.
Okay, April 8th, 9:30 at the office of the Post Commission. And And the offices are at 84 State Street in Boston at Suite 200. Mr. McCall, I'm just stating what the address is for your benefit.
Yes, Your Honor. Thank you.
Okay. And no, since there are no other matters, we will terminate the hearing, and I will see you both in person on April 8th at 9:30. Thank you very much for attending today, both
Thank
Your
you.
Mr.
Honor.
McCall and Ms. Chisholm.
Thank
Thank
you.
you, Your Honor.
Judge Cowin, just quickly,
Yes.
is there a deadline for Attorney Chisholm to notify you if the witness can appear in person for the hearing?
We'll back up a minute. Excuse me, we'll back up a minute. I'll ask Mr. McCall, do you object to, I gotta get her initials straight. Do you object to testifying by Zoom?
I do, Your Honor. Initially, I didn't have an objection because, like you said prior, if there was, let's just say, 8 of the 10 witnesses or 8 of the 9 witnesses that wanted to go forward, I wouldn't have had an issue with 1 or 2 testifying via Zoom if they had an issue. But since the commission only can muster up 1 witness, I believe that witness should be in person, and I should be able to face my accuser.
Okay. All right, Ms. Chisholm, by when can you have something in writing if you have a problem with this witness testifying in person?
I could have it by Wednesday.
All right, if you have an objection to her testifying in person, please submit it by Wednesday, by noontime Wednesday, and provide it at the same time, obviously, to Mr. McCall. And Mr. McCall, if you want to provide something in writing, if Ms. Chisholm provides an objection, filed an objection, you would have to have it to me by Friday.
Okay.
Friday at noon. But my ruling is that she should testify. I definitely think that when the only witness to testify, I think it makes a difference then whether it's in Zoom or in person. So there would have to be quite extenuating circumstances for me to change my mind, Ms. Chisholm. Okay, thank you both, and I hope that I'll see you on April 8th and we won't need another hearing in this matter. Thank you both, and thank you for bringing
you.
that up, Smith.
Thank
Thank
you.
you.